going to move on to our next session. We've got Justice Chamberlain back joining us. We've got Judge Crowshoe, and we have Ronda. Ronda, did you want me to share your last name? I wasn't sure.
Yes, you can share it.
And how would you pronounce it? Dalshaug?
It's Dalshaug. Yeah.
Dalshaug. Okay, let me write that down. Thank you so much. Okay, so by way of introduction, brief indulgence. Okay, so Justice Chamberlain, for those of you who weren't with us this morning, shared with us a deeply moving keynote address, and thank you very much for that. Justice Chamberlain is a member of the Innu Nation. His home community is in central Quebec on the west coast of Lac Saint-Jean. He is a first-generation residential school survivor and was a 60s scoop child. Before his appointment in May of 2019, he was a federal prosecutor in Toronto doing drug and immigration prosecutions and had a specialized practice in restorative justice courts, working in the Drug Treatment Court and the Toronto Gladue Court at Old City Hall since 2003. Previous to his law career, Justice Chamberlain worked in mental health and adult psychiatric crisis intervention in downtown Toronto and worked in an adult drug treatment center in Thunder Bay. He began his work experience in group homes for children and teens with psychiatric and emotional disorders, doing a significant amount of work with the Indigenous community in Thunder Bay and surrounding areas. He has also volunteered in community choirs, the Lawyer Show, and various community-based agencies, such as the United Way, previous to his appointment. Justice Chamberlain is also lucky to have a wonderful partner of 18 years, and they share two wonderful kids. So welcome, Justice Chamberlain, and if I could please introduce Judge Crowshoe, my apologies. Her Honor was born and raised in the Piikani Reserve in southern Alberta. She is proud of her Piikani ancestral roots and carries the Blackfoot name standing alone. She is the first Blackfoot woman to be called to the Alberta Bar, and in December of 2021, she was the First Nation woman appointed as a judge to the Provincial Court of Alberta. Upon her appointment, she envisioned herself playing a role in initiatives that involved the judiciary moving towards restorative and reconciliation court processes involving Indigenous people, and she fulfilled that vision when she and other judges of the provincial court, as well as community stakeholders, established the Calgary Indigenous Court in September of 2019, where she sits on a regular basis. Her interest in this area continues with her involvement in other ongoing Indigenous court initiatives. Judge Crowshoe received her Bachelor of Management degree from the University of Lethbridge in 1989, her Bachelor of Laws degree from UBC in 1992, and became a member of the Alberta Bar in 1994. Her legal career focused largely on providing counsel for First Nation governments and agencies, while her community work included serving on organizations committed to the preservation of Piikani ways of knowing and those furthering youth and education matters. Judge Crowshoe recognizes the significant impact that Blackfoot traditional knowledge keepers have made in her life, and she continues to support their efforts in furthering Blackfoot culture and traditions. Welcome, Judge Crowshoe. And finally, we have Ronda Dalshaug. And let me find your bio here, just one moment. So Ronda has been employed with the Elizabeth Fry Society of Calgary since 2015, previously as the program manager and currently as the, and I don't want to mess this up, could you help me with what the word is, please?
Yes, it's Soxabatabusin, and it's Blackfoot for Good Life.
Soxabatabusin?
Batabusin, but
okay,
that's why I wrote case management beside it, so you didn't have to say it.
No, I'd like to try, so thank you very much for that. So she is currently working as the Soxabatabusin coordinator. The Elizabeth Fry Society offers pathways to healing through supports and advocacy for women and marginalized populations who are affected by systemic social issues, which can attribute which can contribute to criminalization. As well as working with the Elizabeth Fry Society of Calgary, Ronda also is an instructor at Lethbridge College and is currently completing her final year of her Master of Public Safety. Prior to her employment with the Elizabeth Fry Society of Calgary, Ronda worked as a probation officer in both Saskatchewan and Alberta with both youth and adult for 12 years, 8 of these years in a supervisory role. Many of the individuals on Ronda's caseload were residents of First Nation communities. Through her work with probation, the Elizabeth Fry Society, Calgary Indigenous Court, the Soxha Batabusin Community Case Management Table, and teachings from elders, Ronda has gained her knowledge regarding Indigenous restorative justice practices. Ronda considers herself as an ally to the Indigenous community and has a passion for promoting the recommendations of Truth and Reconciliation Commission and supporting individuals to address the results of colonialization, such as generational trauma, residential school, substance use, and mental health through restorative justice and traditional ceremonies and supports. So thank you, Ronda, so much for joining us. And to our wonderful panelists, I'll turn it over to you and remind everyone, if you have any questions, please feel free to put them in the Q&A. Thank you so much.
All right. If I remember correctly, I think we agreed that I was going to talk first a little bit about the Toronto Drug Treatment Court. The Toronto Drug Treatment Court, the Toronto Gladue Court. The Gladue Court started back in around 2003, and it really came out of an initiative with Justice Patrick Shepherd, who was one of the founders, speaking with Jonathan Rudin and Ken Roach after a conference where they realized that the Gladue decision had come down and not much seemed to be happening. It didn't seem to be applied, so they decided to start a court informally in Toronto, where folks who would self-identify as Indigenous could come and have bail and sentencing matters addressed. And so it began really kind of in an ad hoc fashion, and in many ways, it's continued in that way. We have a number of stakeholders involved. Obviously, the federal crown and the provincial crown are partners there. Aboriginal Legal Services, which is an agency that provides a lot of services to the Indigenous folks in the city of Toronto, from case management to counseling to they do reports and other things. Also provide a great deal of support to the court. And what we began doing is we would have monthly stakeholders meetings, the operations committee, where we would discuss how we would do things, and we began to try and essentially accepting that we were still the white man's court, that wasn't going to change, but we were going to try and make it more comfortable and more respectful of Indigenous folks and Indigenous traditions, as much as to the extent that we could within the court itself. So it was a court where we started, making sure that we address the principles in the Gladue decision, making sure that we address the issue of overrepresentation. And as we began to learn and grow, we also started to adopt some of the different teachings and different learnings within our court as well. So we would do a smudge every day at the beginning of the court, and then throughout the day if anybody requested one. We started sentencing circles about 7-8 years ago, finally getting to the point where we were comfortable enough having matters dealt with in the sentencing circle, as opposed to the traditional form of sentencing, where we had everybody sitting in a circle and everybody would have a voice with respect to talking about the background of the individual who was before the court, the offense itself and what brought them to the court, what they'd been doing since the offense had been committed, and then moving forward, how we could move forward. And then, we would do various go-arounds. We would involve elders, Aboriginal Legal Services. The interesting thing about Toronto is that Toronto doesn't have a particular Indigenous community or Indigenous nation that's connected necessarily to the city of Toronto in ways that other communities might have. So we really are, in many ways, like Toronto is a bit of a multicultural city is also very much diverse in terms of its Indigenous population. And so we end up kind of either relying on the connections and the systems that people may have within their own community, within their own circles, and or from the resources at Aboriginal Legal Services. The other program that Aboriginal Legal Services has done and did before the Gladue Court started was a community council, which is a group of elders and respected community members who, when charges have been screened by the Crown as appropriate, the charges would be stayed right at the front end, and the individual gets referred to community council, where they would meet with a smaller group, a number of elders or community leaders, and they would talk to them about what is it that brought them to the court, and what is it that their challenges are, and then might give them some tasks, whether it be connecting with the cultural community, addressing addiction issues, addressing housing issues, or any other numbers of issues that they're dealing with, and then have them report back to the community council. And then once they've completed those tasks, then they would then be released of any obligation to the community council, but by then already the charges would have been stayed and they were not involved in the criminal courts. So those unfortunately end up dealing with a lot of some of the more minor offenses that we have in the courts, a lot of theft unders, a lot of fail to attend, fail to comply kinds of charges. But we don't have yet a formal process for having a kind of a group participation in dealing with that, other than in the sentencing circle. But at that point, when the individual's already pled guilty before a particular judge, and then it happens at sentencing. So for us, it's really been just trying to make the court a little more comfortable and a little more respectful of folks. And it's those things, those little things, I think, that can make a difference. There's nothing like walking into a court when we know that there's been a smudging, and you can smell the medicines. You can smell the sage or the sweetgrass, and that sends a message to an Indigenous person who's had that, who's relied on that for their own experiences. I think when they walk into the court and do that. We've also tried to address some of the other issues in the community that we've dealt with. We've had in Toronto, as in many other communities, a significant number of overdoses as well. And so we were doing for a period of time till the pandemic, of course, a honoring ceremonies every season, where we would talk about grief and loss and honor the people that we had lost during a certain period of time. And we didn't limit it to just the folks coming through the court. People were invited to participate and share their experiences of loss and grief as well, and talk about that. And it was led by one of our elders, Dorothy Peters, who's been a significant leader for us in the Toronto Gladue Court. And then the other thing we would do is we would try to also just mark other events, like over the holidays, we would try and bring food when we could, and have an open house, midday, so that participants and stakeholders, the judges and crowns and lawyers, could come and celebrate and partake of a bit of food and a bit of cheer, and just socialize in a way that isn't just the kind of formal things that we do in court all the time. So I think what we've tried to do is try to come up with a way that, as I keep repeating myself here, that addresses the kinds of needs, but also does so in a respectful way. So that's the kind of things that we've been doing. We're now looking at a new challenge because, in Toronto, there are some 5 or 6 different courthouses and that kind of each deal with a region of the city based on the Toronto Police Divisions. But starting in the spring of 2023 or the summer of 2023, we are moving to a centralized courthouse in downtown Toronto, where all of the courthouses are going to be amalgamated into the one location. And there's going to be a Toronto Bail Center at another location where all the bail matters will be dealt with. And so we're now just looking at how we're going to amalgamate these 5 different Gladue courts that we have in town into one. But we've been really lucky to have partners in the building of that courthouse that has given us 2 designated courts that will now not have a dais. So we're going to be sitting in a circle, and there'll be also ventilated such that we'll be able to do smudging and ceremonies in those courtrooms. And so we're very excited about that. But right now we're just working on how are we going to amalgamate these 5 courts into one and make sure that, coming in, the practices are smooth and there are fewer bumps in the road. So we've just begun that process, but we're very excited about it. There's been some challenges in that too. I think, we've had to address, as we reposition and as we move to the new courthouse, sometimes, stakeholders will reposition and reconsider things. And so they begin then to want to change their practices. And so we've always had, for instance, designated judges and designated crowns in the Gladue courts for the most part, so that they're folks who have experience and who have a commitment to the principles and to making a change within the criminal justice system. And we've had a bit of pushback on some fronts, about whether or not we should have dedicated folks in there, and whether it should be just, and a judge is a judge and any judge should sit in there, or any crown may be part of that rotation. So we're having those discussions again, which is in some ways frustrating and unfortunate, but it's part of, I guess, of change that everybody repositions and everybody tries to move forward in a way that they think it works for their own interests. So that's been an interesting challenge, but we're all kind of certainly as a team working together to try and make it a more positive move, and so we're very excited about the new courthouse and how we hope it'll keep moving in a very positive way. So that's a little bit about what we do in Toronto, and I'm anxious to hear about what my colleagues are doing out west. So thank you. Oh, I think you're muted, Justice Crowshoe.
I'm going to switch over to my PowerPoint presentation. So good afternoon, everyone in Ontario. In respect of my discussion will be on the Calgary Indigenous Court. Our court really was established after, in 2018, when we came together, some judges, community stakeholders, our traditional knowledge people, a person who guided the process as well, to determine how we could best, start to look at the Truth and Reconciliation Commission's calls to action, and how we can basically translate that into a Indigenous court. So we commenced our meetings and brought all the stakeholders together, and basically that came to fruition in September of 2019. And we opened on September 4th of 2019, and you'll see on the left-hand side as a picture of our traditional knowledge keeper, Leonard Bastine, who also goes by the name of Leonard Weasel Traveler. He's a Blackfoot ceremonialist and who came and basically stood in the stead of our and guided basically the cultural component of our court. So he's a very central part of those discussions that took place. To the right of him is a retired Judge Eugene Creighton. He was part of the committee as well as myself. We had another judge who basically had that information about Indigenous peoples from the work we've done. And both Judge Creighton and myself are Blackfoot people. We're from 2 respective First Nations. I'm from Piikani. Judge Creighton was from the Blood Tribe. So we came together with that knowledge along with other members of the judiciary at the time, our Assistant Chief Judge Joanne Durant, as well as our Chief Judge Terry Matchett, to basically all the parties together to start the process of establishing the Indigenous Court. And what our court wanted to do, and again, we're looking to some of the language, used by, the Supreme Court and what we call the Gladue decisions, and what the Supreme Court had basically, noted in their decisions, and that what we wanted to provide was a culturally relevant and restorative and holistic system of justice for Indigenous individuals, including offenders and victims in the community harmed by the offender's actions. And again, through our healing plan to address their unique challenges and circumstances of those persons who we call participants in our court. And that's how, basically what our vision was at that point in time. This is a picture of the Indigenous Court itself, and you tell, it's we sit at a round table. If you look straight ahead, you're going to see where the judge would sit close where the windows are. The courtroom was basically designed after a ceremonial teepee. And in our ceremonial teepee, directly ahead would be where the ceremonials would sit for the ceremony itself. To the right of the judge would sit the clerk, and to the right of the clerk and closer to the opening would be the participant or the accused person before the court and the prosecutor. On the opposite side, on the left-hand side, you'd have usually it would be the person who's working with our case management table who would sit there to provide the information to the court on each participant before the court. We'd also have our elders sit at the table as well, and then we'd have our the prosecutor, sit at the table as well. In respect of the court, if you look to the ceiling there, it was designed after like indicated by a TP. You'll see the metal spokes coming from the center of the ceiling. Those are to depict TP poles in a TP. You'll see the center of it is there's a hole that would represent the hole of the TP. If you look down to the floor, you can see a granite hearth. That's where our elder who would come in usually at 8:30 in the morning prior to court to basically light a smudge for everyone who's going to participate in court that day. In respect of our Blackfoot ways, usually our elder provides a smudge, and one smudge really is basically for everyone who's participated in the ceremony itself in the teepee. So we don't usually have different person smudging during the day. We usually have the one smudge in the morning that's really basically for the benefit of everyone in the courtroom for that day. So when you look up to the ceiling again to the where the teepee poles would be, you can see that opening. That's where all the smoke would emanate out of the courtroom. It's also our ventilation system to the courtroom that was put there when the court was established to basically accommodate smudges in the courtroom itself. Around the table itself, you're going to see the different colors. It's also, again, we could call the medicine wheel, the colors of different, natural elements of the earth, the sky, the water. And each Indigenous group will have their own interpretation of what those colors mean. When the Indigenous Court was opened, we asked the elder who sat, which was Leonard Bastine, who you see the picture of, and he said, well, his interpretation of the colors, and he said again, each Indigenous group was going to have their own interpretation. He said for Blackfoot people, he said the color black is very significant in our ceremonies, and some of our sacred societies use the color black. So he said if you put all those colors together, that makes the color black. And he said that's why it's, those colors are significant, not only for the colors that they represent, but also when you put all the colors together, what they represent. You can see from the courtroom itself, but there's the display units. In those display units, there's going to be representation from people from the north of Canada, from the southern part of Canada, from eastern Canada to western Canada. So they're all depicted in those display cases. So when a person comes in and is before the court, they're going to see themselves represented in some way in this courtroom by the different, artwork, by the different pictures, by the different carvings we have in the courtroom itself. So that's really how our court is set up in respect of a ceremonial teepee. So our function of the court is, we hear bail hearings, our judicial interim release. We also have dispositions. That can be a sentencing or the withdrawal of charges. We are trying to move away from the language of a sentence in court because we believe that sentencing is only one component of that court. In some cases, a disposition may mean after a person successfully completes their healing plan that the Crown withdraws the charges. Or, sentencing, could basically be one of the options as well. So we didn't want to limit ourselves only to be a sentence in court. If we're actually, want to be known as a disposition court or a resolution court. Our court sits every Wednesday. So in the morning we have docket matters. We also have bail hearings. In the afternoons we have dispositions. An elder performs a smudge before the court, usually at 8:30. That was pre-COVID. We'd have the elder come in to do a smudge before court. During this, to observe COVID protocols, the elder performs a smudge at his own home on the reserve, and that's basically again to benefit everyone who's going to appear in court that day, but also to keep our elders safe in the community during this COVID period. The elder will also appear by WebEx during COVID times. Pre-COVID, he'd be in the court itself, and he opens our court with the opening prayer. And again, the opening prayer is for the benefit of everyone who's attending court that day, and again addresses, the Indigenous persons, their circumstances before the court. In our Blackfoot language, we don't have a word for crime, and you'll hear our elder indicate it was a mistake this person made, in their life, and that's what we're trying to address in court that day, to basically address the mistake that they made in their life. So an elder is very important in respect of our court, and especially the opening the court and the smudge and the prayer that's conducted in the court. The court is actually for anyone who identifies as being Indigenous, and again, in Canada, we have, First Nations, Métis, Inuit, and other, status, non-status Indigenous people. So it can be anyone who identifies as being Indigenous can have their matters heard in our court. We also can hear matters transferred from other courts in the Calgary court system. So it could be a regular court matter, and the Indigenous person wishes to have their matter transferred to our court, and so that matter is transferred in. We can also have a matter that originates in the Calgary jurisdiction, and the person the participant may have other matters that arise out of Calgary. So it could be one of the First Nations where those communities are located, no matter where that may be in Alberta, and they could have that matter transferred in basically for a bail hearing or for a resolution of the matter within our court. But the matter in respect of a resolution has to arise in the Calgary area at this time. That's the jurisdiction that for the Calgary Indigenous Court. The matters are transferred in are identified as going to the Calgary Indigenous Court by the Calgary City Police, by the Remand Center, by Duty Council, and by the Crown, the Case Management Office, and the Hearing Office. So usually what we call the Case Management Office, when they have a matter that's, and the person has identified as being Indigenous, usually it will come into our court as a matter of that identification. In other cases, it can be, the defense counsel can ask that it be transferred in. And again, in other courtrooms, other judges can also determine whether that matter can be transferred and should be transferred into our court. And when I'm talking about Indigenous restorative justice, So first of all, there's throughout Canada we have different First Nation, Indigenous groups, and I suspect if you ask each person from any of those communities what's restorative justice, they're going to have their own idea of what that is. And again, there's no defined words for restorative justice. In this case, and in the Calgary Indigenous Court, what we call restorative justice is trying to develop a process for our participant before the court to basically address the trauma and other unique circumstances that have affected their life. And that could be from residential schools. It can be from the effects of colonization. And so we basically direct them when they first appear in our court to go and have the intake and assessment process for a healing plan. And we direct them usually to Elizabeth Fry, who's the coordinating agency at this time for our case management table. Then that healing plan is developed, and the healing plan is going to look and look towards their meeting with the elder, for the elder to determine where this person is in their life, if they're stable enough to have undertake a healing plan, or maybe they need some additional stabilization, like maybe attending a detox facility to address their addictions at that point in time. It may mean they may need 2 elder visits just to determine the status of their current circumstances. Once the elder has met with them, then they're directed into the case management system and are assigned a case monitor. And the plan of the healing plan is to try their best. We don't dictate what they that they have to do this, and there's no breach if they don't fulfill the recommendations of their healing plan. We do expect them to try their best, and usually that is the case. There's times where they're going to come before our court and where they're struggling, and those are the questions that are going to be asked by the judge who's sitting there, or the judge will be notified by the case management coordinator. And so at that point in time, we could direct additional resources to them so that they'll have to have successful outcomes, whatever challenges that they're having at any particular point in time. A person may appear several times in our court, and from I'd say anywhere from 3 months to a year, they're going to be coming through our court. And each time they come in, we're just asking for a update on their healing plan, because we want to allow the participant time to basically address those areas in their life where they need support. So that could be for counseling, it could be for spiritual and cultural guidance, it can be they're going for treatment. So it just depends on what stage they're at. So we allow them that time to do that. And again, we have dispositions would include a probation order when the matter is disposed of, which will always include in the development of a healing plan. And defense counsel is very aware that if your matter is in the Indigenous court, we are going to expect that the participant is committed to development of a healing plan and a continuation of that healing plan, once their matter's been disposed of in our court. So that's really a requirement to be in our court. We're going to expect that the person wants to address the circumstances in their life that will bring them back into, that they heal themselves from whatever their particular circumstances are. So that's part of the process in the court. In our Blackfoot ways, we have one of the things we do is this is a buffalo. In the buffalo, you're going to see the arrow that's our lifeline. What we say in our Blackfoot ways is that the kidneys represent balance in their life. So at different times when a person's in our courtroom, we'll show them the picture and we'll tell them this is what is part of your lifeline. You're trying to restore balance in your life. A healing plan helps them to restore that balance. So once they're successfully and are even on the road to addressing the circumstances in their life where they do need extra supports, they need extra cultural and spiritual guidance, whether those supports are traditional Western forms or whether they're either culturally based, we're trying to have them back into a healthy balance in their life. And so what we, our message to them as well, if you are balanced in your life as an individual, you can probably expect that your family is going to be balanced because you are now coming in back into balance in your life. If you're balanced and your family's balanced, then it's likely that your community starts to be balanced because now we have people that are addressing their historical trauma, the effects of colonization through their healing plan. And now they're going to become more, productive citizens in their own community within their families. So that's one of the depictions that we showed them as they're coming to our court. So so we hear all matters except what we call the 469 offenses. Anything that that arises in the jurisdiction of Calgary, we hear domestic conflict matters, and that can be whether it's going to be domestic violence or it's going to be violence that occurs within persons that may not know each other. We also do waivers or files from other jurisdictions. Again, usually, well, they have to have a matter that arises in Calgary, but we can bring in other matters, in respect of bail hearings or in respect of global resolutions. We have dedicated resources. We have 4 judges who rotate in the Indigenous court, and I heard Justice Chamberlain say that earlier. What we've really noted, for our court is that either you're Indigenous. Usually, we have those that have a lived experience as being Indigenous. We also have those judges who have come in who have that knowledge of Indigenous people and our restorative justice who complement the court. So again, that works best for us. And when we have 4 judges who rotate, we start to and begin to know each and every participant. And I think for a trust factor for a person coming before the court, we want that trust to be in place. And it's like a person coming in, they're going to be more apt to be to tell the judge that they're having challenging circumstances in their life if they trust them, and to trust that the judge is not going to basically address that with any punitive measures, but really that the judge is going to address any circumstances with extra supports that they may need. So trust begins to be a factor, especially amongst the participants and the judges. We have 2 assigned prosecutors who alternate. They have become very, very familiar with the restorative healing process as well. And that has worked well because they also come to know all the participants in our court. And again, they work, and I want to say they work very effectively to basically realize our vision again of a restorative and healing court, and that's what they're working towards as well. We have 1 assigned Judy counsel. She comes from an Indigenous background as well, raised in a First Nations reserve. So she has that perspective, but she's also very attuned to what our vision is for a restorative and healing court, and that's what she works towards as well. We have a case management table, and so that's who the healing plan is completed by, and that's under the coordination of the Elizabeth Fry Society. The case management table, again, they work with each individual person coming before the court, and they will determine what that person's needs are, and then they'll basically bring it into play. If a person has, for instance, FASD. Diagnosis, they'll bring supports in for that person through the John Howard Society. If a person has other, addictions issues, then they're going to bring in those services that offer help with those addictions to support that person. So the case management table really, identifies the agencies that work and will work with that person. We also have, elders who are part of the case management table, but we also have elders and traditional knowledge keepers who work and are based out of the different services and agencies in Calgary. So there is a variety of Indigenous elders that a participant can work with, as well as different programs and services offered within the city of Calgary. Again, when a probation order is made, we would include both traditional and developmental forms of sentencing, but again, a healing plan is always part of that. So in addition to possibly a probation order having direction that they attend residential treatment and our counseling, for domestic violence, we would also have a healing plan developed, and they would do that basically with the case management table, who will identify the needs and what services that they need. One of the essential things into our court is our case management table. Our case management table, again, under the coordination of our Elizabeth Fry Society, addresses each individual, and that is through the elders who they meet with, and also through the agencies and services that the case management table offers to that person. They're an essential part of our Indigenous court. The success of our Indigenous court really has been, with the work with the case management table, because they realize on, the vision of the court in respect of healing and restorative measures to address each individual participant. And again, to bring that participant into a healthy balance and, in their life. And again, so if they're healthy, or, their family will be healthy, as well as the community. So our case management table plays an essential role, and Ms. Dalshaug is going to address that in her presentation. We also have a dedicated bail worker who who works with Native Council and Services of Alberta, and they work with the persons in remand. So when there's a bail hearing, they will actually develop a bail release plan with the inmate, for presentation to the court. Native Council and Services of Alberta also offers a dedicated peacemaker to the court. They participate as well. So the peacemaker will address those participants who wish to have their matter addressed through a peacemaking session. That's one consideration the court has in respect of a resolution of the matter, is if the person participated in a peacemaking session, and that'll be part of the consideration of the court in cases where peacemaking is appropriate. The Gladue factors, what we call, and again, under IPLI and Gladue, what we come to know as Gladue factors, and those are really factors that arise out of historical trauma, or the effects of colonization. So those are basically identified as part of the bail release plan. So when that plan is made, and a person is released from custody, we don't automatically attach a healing plan to that person's next appearance in court. We basically schedule them to appear at the next sitting of the court, and then we'll ask them at that point in time, do you want to remain in this court to address your matter? If you do, then you will be, and we'll expect you to have a healing plan developed. And so any person whose matters addressed through bail can also participate in the court after their bail hearing has concluded. Again, we have with respect to the involvement of victims, we have Homefront, who works with the domestic violence victims. And so they sit at the table and to ensure that the victims, voice is heard at the case management table. Again, we have peacemaking, which involves domestic and non-domestic matters. We also, we always have, restorative justice principles, again, through our healing plan that's really put in place so that this person has an opportunity to address any of those factors in their life, again, that were, called the Gladue factors. And again, as indicated earlier, the application of, section 7182 of the Criminal Code to find alternative ways of dealing with a person rather than incarceration. And again, we use the factors presented in Gladue and IPLI as well. We again, through bail, that there also have the opportunity of coming back to the court or working with the bail worker to develop the bail plan that addresses these areas as well. And these are some examples of the our partners at the table, and that would be Elizabeth Fry, who plays a major role, especially the coordinator of our case management table. The John Howard Society, and again, John Howard Society does a lot of the work with our FASD participants. Native Counseling, who provides a peacemaker, the bail worker, and on and on. So we have many partners who support the court. We also have many agencies who are not named here who also support the case management table to provide supports to the participant. And that concludes my presentation. I want to ensure I leave room for time for Ms. Dalshaug to present. So thank you.
Thank you, Judge Crowshoe. I won't take too much time. Judge Crowshoe has mentioned mostly everything that our court does. I'll talk a little bit more just about our table and how we work and how we fit with the Indigenous Court. Our table was actually started in 2016 at the recommendation of the elders we work with our agency. What we were finding is, as some of you in the East may know, and of course anybody from the West knows, the Elizabeth Fry Societies typically work with inmates and people coming out of jail to help them reintegrate back into society. And what we were seeing in Calgary specifically was the overrepresentation of Indigenous offenders that were being arrested and held and sentenced to custody. But also we were noticing, and as was noted in my bio, I used to be the program manager prior to taking on the Indigenous Court and the table full time. We were noticing that we were getting a lot of repeat offenders and repeat clients into our agency. So it was like, okay, what can we do to reduce this? And a passion of mine has always been the restorative justice. After working at the time that the youth criminal justice system was first coming into play in 2002, within the communities and working within that act and working with youth and working on restorative justice, my executive director had approached our elders and said, we want to do something that's more restorative. We want the clients, and as Judge Crowshoe said, we call participants because they are a big part of their own healing plans. But we want them to be getting what they need to help them to start to cease all of their involvement, not only in the criminal justice system, but it's a domino effect, working with Child and Family Services and other agencies that were causing and did cause the harm that led to their trauma to begin with. Our elders led us to this table saying that we needed to work as a community. In the Indigenous culture, everything is done in community. And so for years, all of the agencies, and it's like this, I'm sure, in any big center, where the agencies work in silo. And a lot of that reason is because of funding. We're all fighting for funding. We all need funding for our programs to run. We're all nonprofit. And I think this needs to be noted right now too, is we do not, this collaborative table, the case management table, talks about abuse and does not receive any funding federally or provincially. We are ran by other funding mechanisms, which I think is also a bonus working with the courts, because Alberta Justice does not dictate how the table runs. Not that they do. I want to make very clear that we are a very collaborative court. Our 4 judges, our Crown, our duty council, and the table work very closely together. We, even though, as Judge Crowshoe has pointed out, our court sits every Wednesday, our jobs run week long. For instance, on Monday, our table meets. On Tuesday afternoons, I attend our Indigenous court meetings, which include the Crown and any defense who have clients appearing in Indigenous court that week, for us to sort of discuss what's going on with them and have talks outside of the courtroom. That is mainly to save some time in our court, because as I'm sure you can imagine, with the city of 1.5 million people in Calgary, I know that's small compared to Toronto, but we do have a very large urban Indigenous community, and that is where all of our clients are coming. So our docket gets quite full quite fast. But you know, it's an ongoing thing. And then Wednesday's court, and then Thursdays, you know, we're as a table, we're starting to meet with more clients. We're doing some new intakes. It's just a continuous process. But I think where I do want to focus a little bit is, like I said, on the table. So we are a table of community resources. Although I am the coordinator, I definitely do not make the decisions at the table. That is made as a table, as well as the participant is a big part of their own healing plan development. So foremost, we have an elder that attends every one of our meetings. She is one of the elders that Elizabeth Fry has sought knowledge and direction from for quite a few years. She sits at our table, but we also have a variety of provincial, municipal, and community agencies. So Calgary City Police, we have an Indigenous police officer who is our Indigenous liaison officer for the Calgary City Police. We have, as Judge mentioned, FASD support workers from John Howard. We have the victims are represented by Homefront, who is our domestic violence victims agency. We have treatment centers. We have 2 Indigenous treatment centers right in the city of Calgary. We have Simon House and Sunrise Treatment. Both of them are represented at the table. We also have other Indigenous programming agencies, such as the Aboriginal Friendship Center, as well as we have probation officers that are dedicated to the Indigenous court, and all of the participants in that court, if they're sentenced to probation, if they're on a Form 11 or have conditions, they are assigned one of these probation officers who attend our meetings. So we work as a very well-oiled group. And when the participant is referred from the court, there is a really short referral process. It's basically the lawyers say, we have a client that wants to participate. We take a look at that client and where their issues lie that have brought them to the court. And we start as a group to decide which agency would be best linked to that person. And so we start to link them to the agencies. And sometimes, you know, it is addictions and they do have to go to treatment first. And I wish I had a lot more time and Judge Crowshoe could help me, but the elders tell us that there is no such thing as addictions either in the Indigenous culture, because the alcohol and addictions never started till colonization. So what had happened was the alcohol was brought in. So there's no real treatment. There's ways of culture that they work with people, but any ceremony or any teachings that people receive, they have to be sober and they have to be spiritually open to receive those teachings. So although we use a lot of cultural practices, we still do incorporate mainstream services and programs as well. Another area where we do this is with mental health. We do need psychologists and psychiatrists to deal with some of the deep-rooted trauma, but also some of the more severe mental health, such as schizophrenia or bipolar. And sometimes they need to be medicated prior to being able to participate, just for everybody's safety, including their own. Once they come to the table, the first step after coming to the table and me introducing them as a new intake is they begin to meet the elders. And the elders, as Judge Crowshoe has said, will provide our recommendations. And this may take 1, 2, 3 visits. It depends on the person. It depends on what the elder is feeling. The elder has to build a rapport with these people. Most of our participants are very institutionalized. They're very used to being a power and control type of environment, whereas we do not operate that, the court or ourselves at all. As Judge Crowshoe said, it's always conversations. You know, if a client's struggling, they come back to court. Even the judge is providing some support and, you know, encouragement to the client. It's not that they're breached right away, or they're sent to jail or thrown out of the court. We do everything we can to help that person along their healing journey. But if they're not ready, there are times that they go back to the mainstream court. But we have no limit on how many times somebody can be referred to the table or the court. They keep coming back until they're ready to make their changes. After the elders meet them, after several meetings actually, so we do start to get recommendations, then their healing plan really starts to be developed. And it's based on a lot of things. It's based on mainstream programming. So do they need mental health? How often are they going to see that counselor? You know, they're going to go to treatment, but it also holds the cultural components as well. So the elder will say how many times they feel they need to work with them, what ceremonies they may want them to attend, what Indigenous programming they may want them to participate in as well. And so that's the real beginning of a healing plan. And those healing plans are actually reviewed every 3 months and they're updated. Another thing to note is when their sentencing happens, and that can happen at any stage, that's not the table's discretion. That's not our job. I do not have a law degree. That's why we have the judge and the Crown and the defense. But even after sentencing, even if their charges are withdrawn, the participants are encouraged to continue on their healing journey. The elders tell me that the Indigenous people were born on their red paths. They were born on walking that red path of a healthy journey. And what's happened with colonization is all of these barriers have been thrown onto their path, whether that be addictions, mental health, trauma. And they have to start clearing that path, but they have to continue on that path. It's not a time sensitive path. It is a journey for life. And what we're trying to do is what the restorative principles have pointed out. We want collaboration. We get that with the courts, with the members, with the clients. Inclusiveness. As Judge Crowshoe has indicated, we have no criteria. I joined the last presentation right at the very end, and when the presenter had said, you know, sometimes our criteria are barriers. That's why we don't have any, other than because we don't do trials and we don't do the serious criminal offenses. That is otherwise the only criteria. Otherwise, all they have to do, they don't have to provide us any proof. They just have to identify as Indigenous. Safety and respect. Safety and respect is given both inside the courtroom as well as at the table. By the participants all feel that they're respected and that they're safe in our environment to talk openly and without fear of punishment. The victims are represented and they're more than we're more than happy to have them participate in a healing plan themselves. Most domestics that our participants are facing charges on, of course, their partner is Indigenous. Both of them have faced the same traumas. And so why not allow the victim to develop a healing plan and work on their own healing and eventually go to peacemaking together? As well as the community. The community is all of us that sit in the court. So there's a safety and a respect of all aspects, but we also consider community safety. Just because you're in our court does not mean that your charge will be withdrawn, that you'll get probation. You may end up incarcerated, but the elders also tell the participants a part of your healing journey is facing your past, and the past is the charges that you're in front of the court with. We're flexible. We have to be. We're dealing a lot of the times with homeless people. We're dealing a lot of the time with very deep-rooted trauma, mental health, and addictions. And as I said, we will keep taking people back till they're ready to go on their journeys. they are held accountable. They're held accountable because the healing plans, even though the court's expectation is people will participate, we have no legal jurisdiction over them at the table, so we don't handcuff them to their healing plans. We don't, probation doesn't breach them on their healing plans. So they're accountable for not only the consequences of their actions that got them involved in the justice system, but also of participating in their own healing plans. And then finally, it's the transformation. We have been actively running since September 2019, as Judge Crowshoe had pointed out. And unfortunately, COVID hit shortly after we started our court. And so we lost a few people, but we were due to an inability to connect with them. A lot of them don't have phones. A lot of them went back to the nations and were in very isolated areas. But we've had the opportunity and the pleasure to see many of them complete their healing plans or continue on with their journey healthy and not receive any new criminal charges, or if they did, they're farther and fewer between, they're less violent. You know, they may have been a breach for a reason that really we can talk about in the court and deal with. So, you know, we've been in operation a very short time, but we have seen the improvement within our participants. And a lot of them come back to the court to provide how they've been doing, to provide reports to the court, to let us all know they're still doing really well, but also to act as an example for the new participants that we have coming through. Unlike some of the other specialized courts, we do not limit how many we have. So we do not limit at our table either. We could have 300 files active at one time, or we could have 5. It's all dependent on who wants to participate. Another thing I can't emphasize enough, because I said to Judge Crowshoe and our other judges so many times, is, you know, although don't have a law background, I've spent most of my career in a courtroom as a probation officer and then with EFRI as an advocate for our clients. But what I love about our court is the collaboration. And so when we have our Crown meetings and I have to give a bad report on somebody, and it's not a bad report, it's struggles in our Crown meeting with the Crown sitting there as well as the defense. At first, the defense, they weren't too happy about it because they thought that, you know, the Crown was getting information to hold against this person, but that's not at all what our Crown does. And that's not at all what our meetings are for. Our meetings are very informal. The judges are not present, but it's not meant as a disciplinary. It's meant as a healing and as also an opportunity for the Crown and lawyer to say, you know, to put their heads together with us to say, what can we do for this person? So that our table fits in very nicely, but our table is very separate from the court. We were a part, my executive director and myself were a part of the team that developed the Indigenous Court in Calgary. We also work very closely with our, at the time, Assistant Chief Justice Durant and Judge Crowshoe to make sure that the court and the healing plans were melding and we're working well together, and we continuously are making improvements or changing things to make it better for the clients that are attending our court. So I see that I went 5 minutes over, so I will stop there, and thank you so much for having us.
Thank you to all 3 of our panelists that we've just heard from. It's really important work that you all have been and are still a part of. Thank you so much for sharing your experience and insight with us. We really appreciate your time, and hopefully you can stick around for our next session. If not, all the best to you and keep well. Thank you so much.